A Brave New World, the Future of Technology Regulation. Kind of hard to believe, but in our new COVID-19 reality, big technology companies have become even more important than ever. They provide the software, hardware, and virtual platforms that allow Americans to move their lives essentially online, permit doctors and scientists to share information about potential treatments, and facilitate the spread of best practices on how to keep our families and communities safe. And while it's true that these companies have changed daily life across the globe, making us more connected, more efficient, and more mobile, critics have also accused them of violating privacy rights, engaging in anti competitive behavior, and even contributing to our election crises with lax policies on political ads and the spread of disinformation. As a result, the call for them to be more effectively regulated has grown louder in recent years, and multiple antitrust investigations have been initiated to review tech market power. All of this begs the question that was also the topic of yesterday's House Judiciary Antitrust Subcommittee hearing. What should regulation look like? And what are the tech companies already doing to respond to these concerns? Let me just take a second to, of course, thank our generous sponsors for making this possible. We have a wonderful panel of experts from academia and industry who are going to discuss these questions with us today. So to get the conversation started, I'm about to turn it over to today's moderator, Leah Nyland. Leah is a technology reporter at Politico, where she covers antitrust and investigations. Prior to joining Politico, she served for 8 years as chief global correspondent for MLEX, where she helped direct the country's coverage of competition law in Asia, Europe, and North and South America. In 2014, Leah was awarded the Abe Fellowship for Journalists. Her work has appeared in MSN, Yahoo, Politico Europe, Perishable News, Market Insight, and Competition Policy International. We are so glad she's able to join us today and lead this conversation. Leah, please take it away.
Thank you so much, Russ. Thank you guys for joining us today virtually. We're really happy to have you. We have a great panel set up for you with 3 wonderful panelists. I'm going to briefly introduce them, and then we're going to get started. Just a few housekeeping matters. We're going to leave a little bit of time at the end for questions. So if you think of any questions throughout our discussion today, feel free to drop them in the chat box, and ACS will send them along to us for me to ask towards the end of the program. So first, we have Danielle Citron. She is a professor of law at Boston University School of Law. She teaches and writes about information privacy, free expression, and civil rights, and is the author of the book Hate Crimes in Cyberspace. Danielle also serves on Twitter's Trust and Safety Council and Facebook's Non-Consensual Intimate Imagery Task Force, where she advises both companies on online safety and civil liberties. We also have Markham Erickson, who is a vice president for government affairs and public policy at Google. Markham is one of the nation's top internet and media lawyers. At Google, he leads the company's Centers for Excellence, which are a global team of subject matter experts focused on the application of law and policy to technology and the internet. And last but certainly not least, we have Tim Wu, who is the Julius Silver Professor of Law, Science, and Technology at Columbia Law School. Tim has been a professor since 2006, where he writes and teaches about private power, free speech, and information warfare. In recent years, he has been a leader in the revitalization of American antitrust, focusing on the power of technology platforms. His most recent book is The Curse of Bigness: Antitrust in the New Gilded Age. So to kick it off, everybody, yesterday was a very big day for tech and policy here in DC. There was a major hearing before the House Antitrust Subcommittee with the CEOs of Apple, Amazon, Facebook, and Google. So I just wanted to give you guys an opportunity to share some thoughts about what you thought were some of the biggest takeaways from the hearing and where Congress might be going from here. Do you want to start us off, Tim?
So from my perspective, which is, an antitrust person and, someone interested in the current investigations, I thought the hearings were in the genre very successful, in the sense they seem to, put some, what does a good congressional hearing do? It gets people talking, it puts wood on the fire, gives investigators some backbone and enforcement agencies some backbone. And I could say a lot, but I want to dwell on two things that I felt came up from it. First of all, I was actually shocked at the revelations of the documents for Facebook surrounding their acquisition of Instagram. And there was a little bit about WhatsApp, but mostly Instagram. The committee obviously has gotten a bunch of documents, and under current law, they look like a huge amount of trouble for Facebook to my ears. They suggest that Mark Zuckerberg had a sort of a straightforward plan to monopolize and neutralize any threats to him in the acquisition of Instagram in particular. So I think that was a big bombshell, at least for antitrust lawyers. Another takeaway that I maybe will spend some time on is I felt left it thinking that we aren't really settled on how we think about big platforms cloning the products of other companies. It comes up to some degree with Google. Back in the early 2010s, Google was accused of seizing a lot of data from companies like Yelp and TripAdvisor to create their own clones of them. And it came up even more viscerally for Amazon, where you had just endless numbers of people suggesting that Amazon essentially invites them for lunch and then has them for dinner. They have them on the platform, they figure out a lot about them, and then they copy them very carefully. And it's an interesting problem. It's kind of feels a little bit like a copyright or a misappropriation or that kind of problem. But it's something they do. It's something they lied about doing last year, so that was another big development. And something people care about. It's just not really clear if there is a cause of action in that area, but maybe that's something Congress will create, or a common law court will create. But those were my two big takeaways. Apple took some fire, but I don't think anything existential. Yeah, I'll leave it there. I could probably go on longer, but I'll leave it there, as those were my main reactions.
Thanks very much, Tim. It was billed as an antitrust hearing, but definitely the second biggest topic that came up a lot was censorship online and free speech. And Danielle, you are sort of an expert in Section 230, so I was interested in getting some of your takeaways from the hearing, and maybe also there was another very large hearing this week about Section 230. So maybe you can start us off with some takeaways from those.
Okay, so I don't know if our audience is familiar as we are with Section 230 of the Communications Decency Act, which was passed almost 25 years ago. But it was a statute. The larger effort was to basically rid the internet of porn, which now seems kind of quaint. But the Decency Act, its point was to give online service providers and other interactive computer services an incentive to monitor, right? That they would enjoy a legal shield, so a shield from legal responsibility for under and over filtering offensive, I'm going to use the statute's words, offensive, harassing speech, right? It was designed to incentivize good Samaritans, is the sort of subtitle of the statute. And Section 230 is shocking to me, because I started writing about Section 230 in 2007 with an article, Cyber Civil Rights, where I tackled cyber mobs. And Section 230, the debate has come a long way. I called for the reform of Section 230, I would say 12 years ago, and I looked like I was out of my mind. Free speech colleagues sort of said I was going to break the internet. And I think it's pretty clear that where the arguments around Section 230, the providing this legal shield from responsibility, the incentive to incentivize monitoring, right? To incentivize moderation has been really broadly construed. And what it's led to, on the one hand, is basically immunizing sites whose purpose is harm, right? So revenge porn sites that focus on deepfake sex videos, arms lists that broker sales of guns, And Amazon, when it sells, it's the broker of the sale of goods that kill people. I'm thinking of the markup story. They enjoy immunity from responsibility. So on the one hand, it's really capaciously understood, right? And that leads to some dissatisfaction with Section 230 that animates some of me and my colleagues at the Cyber Civil Rights Initiative. On the other hand, Section 230 has come under fire from conservatives who argue that in order to enjoy the immunity, that these sites have to act like neutral platforms, which is frankly insane. It's to misunderstand fundamentally Section 230. The idea is not neutrality. In fact, it is an immunity, a legal shield from filtering too much if you do it in good faith and too little, right? But you see a lot of calls to change Section 230, and that's what the hearing yesterday was noteworthy. I was telling Leah before we started, I don't write about antitrust. Grateful that we have Marcus and Tim here. It is not what I do. But what's interesting was the bird's eye view of that content moderation came up a lot, right? And you saw Representative Gates complain that these platforms, of course, and this is in the genre of power, have so much power and they're silencing the speech of conservatives. I think that's a deeply contested empirical point. There have been studies that show that's just not the case. But if you violate terms of service, if you post hate speech, like supporting neo-Nazis or disinformation and misinformation, you might violate the policies of these platforms. But Section 230 is under heated discussion. There've been hearings all year. So I testified in October before the House Energy and Commerce Committee. And so also this week on the Senate side, there was a hearing with some wonderful folks testifying like Jeff Kosseff and Olivier Sylvain. So we're in an interesting discussion about content moderation and should we reform Section 230? Should it continue to be a capacious free pass to even really bad Samaritans? Should we require neutrality? Terrible idea, right? And so hopefully that suffices for an introduction to what it is and some of the debates today.
Yes, that's great. And so Markham, why don't you give us some of your sort of takeaways from how the hearing went from your perspective?
Sure. Thanks, Leah, and for ACS for doing this, Senator Feingold for your leadership, and Danielle and Tim. It's great to spend some time with you on this. So yesterday, the House Judiciary Antitrust Subcommittee held a hearing on antitrust issues with the companies. I can tell you sort of our messages going into that hearing, which were essentially three. One was to make the point that we are in the business of building products that are helpful to people, small businesses in moments big and small, and that these products and services are largely free or inexpensive and that they are helpful in people's everyday lives. The second point is that we operate, in our view, in a highly competitive global marketplace in which, generally speaking, prices are falling and products are continually improving. Today's competitive landscape looks nothing like it did 5 years ago, and that looks nothing like it did 20 years ago. And so there are questions around, whether there are tipping points in technology, as whether there's tipping points in any sector. And I think it's fundamentally very hard in this space to get to a point where there's that kind of moat around something that's essentially software. This was, and there's an incredible amount of innovation. If one thinks about Google in the early days of search, of course, search engines were a bunch of people around a table looking around the World Wide Web and categorizing the websites that they thought were interesting and relevant to certain products, and then literally making an index of those sites. The next iteration was that plus looking at metadata on websites to figure out how to categorize different websites. And then Google came up with something that was novel and game-changing, which was to copy the entire World Wide Web, make that searchable, and then apply some algorithms to rank how sites should appear relevant to queries. The other point here is that today, even though we're a search engine, we're really in the business of being part of an an ecosystem of information discovery. And that's how we think of ourselves, of competing in that space. And so while we are a general purpose search engine, we compete with any number of platforms, apps, services for how people discover and find relevant information on the internet. And so, an example that we gave yesterday, of course, is that if people are searching for products, 55% of those searches are going to start with Amazon. If one is looking for restaurants, you may start with OpenTable or just an app on your phone that's got that. Or if you're looking to travel, you may start with Kayak or some of those. So we look at ourselves as competing against all of those different ways that people are going to find information. And then the last point is that we invest an incredible amount in research and development. At the end of 2019, R&D spend had increased almost 10 times over 10 years, from $2.8 billion to $26 billion, and that would be $90 billion over the last 5 years. I know those are sort of big numbers and they're hard to contextualize it. The thing that seems important to me is that our investment in research and development has increased over the years relative to revenue. And that to me doesn't feel like a sign of a company that feels like it can sit back and leverage its position in the marketplace, whatever that is, but that feels like it has to constantly be spending money to innovate and to provide consumers with new and useful products. And in the recent CMA study in London, that's one of the findings that the Competition Bureau there found, which was that we make incredibly large investments in our R&D to anticipate technology trends and to develop innovative, relevant, and useful products. And we felt very proud in the fall of being the first to announce quantum supremacy. And so we feel like we do compete in a robust ecosystem, and not just in the US, but globally, of course. And today, 9 of the top 20 internet companies are not US companies, they're Chinese companies. And there are European competitors, there's competitors around the globe. So it is an incredibly competitive ecosystem that we find ourselves in. So maybe I'll stop there and let us go into the Q&A.
Great. Thank you so much for that. So I wanted to start with the idea of content moderation and free speech online. Danielle gave us a little bit of an overview into Section 230, which is one of the main areas of consideration for whether Congress should sort of change the law. But let's start back with a little bit of a bigger question. I mean, can and should tech platforms be moderating content? Some lawmakers have called for them to be neutral. Would that be good for free speech? Danielle, why don't you sort of start with that?
Sure. I think it's requiring or mandating neutrality, and we could do that by regulation. I think is a bad idea. It would mean that the content layer, that companies could not do anything about spam, about stalking, threats, non-consensual intimate imagery, right? Abuse that's incredibly harmful, abuse that's illegal, right? In many cases, sometimes at the borderline, but no the less damaging. And so we've seen some important strides with some companies, though certainly not all, and it's hard at scale to always get it right. But as advocates put pressure and work with companies, we've seen, especially in the really destructive abuse, we've seen some important strides since 2014. And so I think it's a terrible idea. Does it mean that we shouldn't regulate companies? We should, right? Should we, by my lights, we should amend Section 230 and condition the immunity on what Ben Wittes and I call reasonable content moderation practices, and we have statutory language that we proposed. And I'm working with both House and Senate staffers on bills along those lines. Should we require transparency and accountability? Absolutely, we should. Should we require compliance with court-ordered, relief to take down, so third-party platforms take down content that's been deemed illegal, tortious, criminal, et cetera? Yes, we should. Right? But should we say that you have to be neutral, like neutral pipes, like the telephone? Absolutely not. I think it would lead to an internet. I wouldn't want to be a Twitter, which is full of spam and neo-Nazis, right? I'm out. So I think neutrality is misconceived, though I think we are and are due for what I call technological due process, sort of rigor and procedural regularity and clarity, and accountability.
Markham, what do you think? Maybe you can tell us a little bit about how Google does do content moderation right now, and sort of what you guys think about this entire debate over changing the law.
Sure. I appreciated Daniel's remarks. She's absolutely right. Section 230 was never meant to require neutrality. It's not about neutrality. In fact, it's the opposite of that. It's to give companies the ability to make decisions to take down content that violate community standards that they find objectionable to their users. And so shifting it to some sort of sense of political neutrality would be inconsistent with one, what was conceived with Section 230, but secondly, I think rather dangerous. Who would define neutrality? It would be the government. That could change with different administrations. We see a flavor of that in the political debates today, of different parties feeling strongly about what is neutral, what is not neutral, and what should be required to be promoted on the internet and what should be taken down. So I think that's point one. Related to that, there's no doubt that there's more political speech on the internet today and made available to people than ever before in history. So I don't think it's a question of people not being able to access diverse points of view, diverse political speech. So that's point two. Point three is I think one should be careful about using Section 230 to achieve certain types of outcomes. There's some things that I think are appropriate in scope, but for instance, one of the debates that Danielle knows about that's happening in Congress right now is qualifying Section 230 on things like providing law enforcement a backdoor for investigations, to have some sort of way for law enforcement to defeat encryption. Sorry, my screen just, there you go.
Oh, there.
And so I think one has to be careful about that as well. Should we think about tweaks to Section 230 or various approaches that might get at the objectives, the legitimate objectives people have around certain types of content on the internet? Absolutely. I think, though, it's fraught with unintended consequences, and we should be careful.
Tim, do you have any thoughts you want to add here?
Yeah, sure. I do. It's a good question. We could probably spend this whole hour on it. So I like to go back to your original question, which is, what is the internet like without content moderation, or the web, let's say? And it's an idea that is appealing to put out there, but I think, as Danielle says, there's actually a sort of a more abstract level, something about making choices in content moderation which gives any site its identity. For example, let's say you want to have a Reddit segment devoted to a TV show like The Leftovers or something. Well, you have to kind of have some rules. This has been a debate since the 90s. Is everything just a free-for-all, or can you ban the trolls? Can you have a board which is only about conversations about medieval Dungeons and Dragons and so on? And if you want things to be, this is I think the interesting point. If you want things to be diverse, you actually have to have content moderation. Otherwise, everything becomes troll land, or it becomes porn land. It's kind of related. There's sort of an idea that some people say, well, content moderation, suddenly it started recently. It got stronger recently. But if you haven't noticed, there hasn't been nudity on Facebook or most websites, YouTube, since the beginning. It's not as if people don't try and upload stuff to YouTube. It's just that it's taken down, flagged immediately, and now I think automatically taken down. So that's right. And I think there's even more to it than, Danielle, I'm curious why she said you could do this by regulation. Because I think I am not the biggest backer of a strong First Amendment, but I think there are First Amendment rights in here In other words, if you are running, like I said, something devoted to sourdough bread, and they say, hey, how come you're not running my posts about the need to overthrow the Federal Reserve and vote for Trump or something? This is anti-conservative bias. And we want to talk about whatever we want to. I think the sourdough website has a First Amendment claim that's pretty strong to say, listen, the way we have our message, we create our community, is by not running a certain content and throwing out the trolls. That's a big part of it. And there's an association right even in there too. So I think, I don't know actually if you can do this neutrality. And I also don't know, to get more technical, who has the power to write rules around Section 230, if anybody. That's getting slightly into FCC law, which I'm sure 99% of this call, other than maybe Markham, is not interested in hearing about too much. But I don't even know if you could do it. So those are some big picture observations. Can I say one last thing? All that being said, I do think, and this is a link to antitrust, even though I do think it's really important for people to be able to take stuff down in order to create a sort of a real diversity of content and themes, it does suggest the need for antitrust enforcement in this area. Having every social network owned by one company or two companies, maybe a few, it does concentrate the Republicans have a point about this much. A concentrated censorial power is something to be concerned about at some level. So even though I believe in this, I don't think it should be completely, everyone should wash their hands there. We don't have to worry about anything in this area. And I just want to make that point. There is a lot of private power here. And there is, by necessity, a lot of private content control. That is something that can be dangerous. I just want to throw that out there.
Thanks. This was actually a really interesting point that came up in the hearing yesterday in a conversation between Chairman Cicilline and Mark Zuckerberg about what responsibility Facebook has in terms of moderation. The exact questions were about disinformation related to COVID. Facebook noted there had been a video by Breitbart that Facebook eventually took down, but in the 5 hours before Facebook took it down, 20 million people had viewed it. So I think there is a question about who the responsibility of a platform when it is that large to remove potentially harmful content. So Danielle, maybe you could start us off. You talked a little bit about some thoughts you have, but how do you think we should try and fix Section 230?
I'd like to respond to Tim's question about the kind of regulation that we can have consistent with the First Amendment, which is sort of transparency and accountability requirements. I think we can square with the First Amendment. That is requiring companies to be clear about what kind of speech they allow and don't allow. It wouldn't change their ability to ban speech that they didn't want to. Right? It's like a private company, like a diner. They can say we accept this kind of speech and not other kinds of speech. They're not a state actor, though incredibly powerful. And so I think we can square, and I began to make arguments under doctrine and theory, First Amendment, free speech theory, that we can require companies to be transparent about their speech rules and policies, and then have mechanisms of accountability, a sort of form of due process that, of course, they're not required, they're not state actors, but we can so mandate. And what's interesting is that the First Amendment, right, would not, let's imagine we took away Section 230, right? Platforms, their offline cognates, right, can be responsible for enabling torts and crimes, right, negligence theory. So too with platforms, right? If we took away if we did, and I don't think we should, but if we did, it's consistent with the First Amendment that a platform could be sued for enabling a tort and a crime where it's really difficult to find the wrongdoer, right? So that's first things first and completely consistent, I think, with the First Amendment. And the notion that these platforms are the idea that they're First Amendment speakers, meaning that government owes them, right, hands off, right? They're speakers in their own right. I'm not going to quibble too much with. So there are ways in which narrowly we can, I think, regulate platforms vis-a-vis speech And we certainly do it all the time with their offline sort of analogs. Now, your question, right, Leah, was how should we reform Section 230? Now, what I would do is I would keep the immunity, but condition Section 230C1, that's the underfiltering provision. I would guarantee the immunity for sites that engage in reasonable content moderation practices. And what's reasonable vis-a-vis threats, such contextual inquiry, is really different from what's reasonable and ever-changing vis-a-vis non-consensual intimate imagery, is different from what's reasonable for other types of illegality. And so I have specific statutory language that I'm happy to share and can actually cite it from memory probably, but that's the, which we don't want me to do, right? But that's the idea, right? I see Leah laughing. The idea is that Section 230C1 shouldn't be a free pass, right? The under filtering, bad Samaritans shouldn't enjoy it, right? That in order to enjoy the legal shield for doing too little, that you have to engage in reasonable content practices vis-a-vis clear illegality that causes significant harm, right? That's the language that I suggest with them. And we have a provision, Section 230C2, which talks about when companies or platforms are too aggressive, when they take down too much, Congress sort of bargained for that. They said that if you take down too much, you filter offensive speech, I'm just using the language of the statute, you got to do it in good faith. Right. And we've really not tested that provision out before. So when, Representative Gates complains that we're filtering too much conservative speech, it's actually something that if they do it in bad faith, you need a legal claim. And that's kind of the problem here. It's like, we can complain about over filtering in bad faith, but you need a legal theory to bring to a court. Right. And there just is, it's hard to come up with one. Right. And so Section 230, for all of its flaws, there's some important features, right? It's given us the internet we have today. The internet's, though, now grown up, right? And 230 has its excesses. So I'd like to rein in some of those excesses.
I do want to move on to antitrust, but I wanted to see, Markham, if you wanted to offer some last words on this topic. You seem to suggest that you thought that there might be some ways that Section 230 might be amended that you guys might be okay with. So.
Yeah, well, I think the underlying point there is we're not against regulation qua regulation, right? In other words, anything goes at any time for any type of content. That would certainly not be appropriate or good public policy. I think the question is, if we are going to change Section 230, then what are the parameters? For those that aren't necessarily familiar with the law here, to clarify in terms of illegality, so Section 230 does have a specific carve out that does not allow companies to take advantage of the immunities in Section 230 for crimes, for federal crimes. And Title 18 is incredibly large and incredibly broad and includes theories of contributory liability as legal matters for facilitating illegal action, aiding and abetting, and so forth. So I think how I would probably come out on this is, let's be careful of unintended consequences. Let's be careful of trying to fit in changes that fit particular ideological viewpoints in the short term, and be focused on specific harms that we're trying to address. I think there are good examples that are tough situations that one can look at. I think a general reasonableness standard to the first paragraph in Section 230 C1, Daniel will correct me, is potentially a little bit too much in that what is reasonable would assumably be developed under case law. It creates a lot of churn and I think more churn than's required in terms of dealing with certain public policy harm. So I think that's probably the way I think about it.
Okay, great. So I want to move on to antitrust, my favorite topic. So the hearing yesterday was sort of the culmination of this year-long investigation that the House Judiciary Committee has been doing into like sort of a broader question, which is, can the antitrust laws, the US antitrust laws as they currently exist, effectively deal with digital platforms. And Tim, you had a couple comments about this in relation to copying, but I wanted to sort of open it up for you to start there. I mean, what is your impression after yesterday about the status of U.S. antitrust laws and whether it can deal with some of the problems that were raised during the hearing?
That's a good question. And maybe just for the benefit of our audience, maybe I'll give some background that I think, Leo, you and I have as to where these investigations are that other people might not know. So there are, just as way of background, well, everyone knows what the antitrust laws do. They're designed to control, punish abuse of monopolies and prevent mergers that are anti-competitive. And the state of affairs is that there are known open investigations into Google and Facebook, a sort of apparently investigation to Amazon, although it doesn't seem to be very active. And the Google and Facebook investigations have states involved in them as well. The Texas AG is kind of the ringleader of the Google investigation, and the Facebook one I think is probably New York, although because I used to work there, they don't tell me anything. And I also used to work the FTC, so they don't tell me anything either. So it's widely expected that the complaint against Google will be filed before the election, mainly centered on advertising markets, which is something that didn't show up much in the hearing. You got some of the preview of Google's defenses from Markham earlier. After hearing the hearing yesterday, I'm surprised that the FTC is not moving more quickly to file a complaint against Facebook based on the idea that it gained a monopoly or protected its monopoly with an acquisition program targeting Instagram, WhatsApp, a whole bunch of other companies. The sort of serial acquisition or defensive monopoly through acquisition strategy. Given that Mark Zuckerberg was so open and blunt about it, he just said, here, it's very obvious to us, these companies are threatening to us. Once you build enough power in a certain area of social, you can't be overtaken. So we have to buy them. It's probably worse than the Bill Gates tidal wave memo from the 90s, or at least very similar in terms of revealing anti-competitive intent. So that's where things are. What did we learn yesterday in the hearing about, is U.S. antitrust law up to the job? I think the answer is yes and no. So for some of the stuff that people were complaining about, there were traditional antitrust answers. Turning back to Facebook, if you run a program where you identify threatening companies and acquire them all, that is actually exactly what Standard Oil did and why they passed the Sherman Act in 1890. So in terms of antitrust law having a handle on that one, they've had that was kind of the original sin. In fact, exactly what Facebook was accused of, which was, and Amazon was accused of this too with diapers, which is aggressively hounding one of your competitors, threatening them, and then trying to buy, and then giving them a choice, either join us or be exterminated. That was exactly the strategy that Rockefeller used in the Standard Oil case, and one reason they broke the company up in 35 pieces. So for that kind of stuff, antitrust law in good shape. But for some of the other stuff that people are complaining about, and here I'm going to use the word cloning, not like Star Wars or human cloning, but the practice of essentially running a platform, inviting everybody in, open platform, and then creating your own version of the most successful stuff. And some people use the term eating the ecosystem, Tim O'Reilly. The state of that kind of conduct is really uncertain. And I would feel much less comfortable bringing an antitrust case on that theory just alone without a lot of other stuff. Sometimes people have bandied it around, but it's a little shaky. So that kind of stuff that people seem to care about. And as we talked earlier, and you just mentioned, Lee, it has a little bit almost of a copyright or a misappropriation feel. You know, what happens when you design a a thing that sits in your backyard that you can hit a golf ball into, and people love it, it's great. And then Amazon makes the exact same thing, but without it being a design patent or anything like that. And they spy on everybody to know, how to price it and who to advertise it to, and then manage to replace you. What is that? Some people would say that's competition. That's great. It's true, it's saving consumers money. But I increasingly feel that that's something a lot of people care about. It's not an obvious remedy in the antitrust law. So maybe that's something people could figure out some way to deal. But anyway, that's something antitrust law does not have a clear handle on. And there's other stuff, obviously the censorship or the alleged censorship is not an antitrust offense, but I guess I'd say it's a side effect. If you have too much concentrated, the internet used to be hundreds and hundreds of companies, and now it's, especially the US internet, about 4 or 5 big ones. It's a concentration of speech. So that in a sense is something that antitrust law cares about indirectly.
Okay, thank you. Markham, what is sort of your take on that question? Can the antitrust laws as they exist now effectively deal with digital platforms?
So in the US, the antitrust laws are focused around consumer benefit, consumer welfare. I do think that's the appropriate place for it to stay centered, but I will agree with those that say it's too narrow for us to think about that as if prices are going down, if things are free, then that's the end of the inquiry. That is only a price-focused inquiry. I think the consumer welfare standard is robust enough to include concepts such as quality of product, quality of content. Some of that gets to what we've talked about today, diversity of speech and other things. One could see potentially those issues being included. In our case, I think it goes to some of the issues around that were raised yesterday around display on real estate and the quality of what consumers are getting for their inquiries. So I think I would agree with the premise that it's too narrow to only look at price effects. And that, but I'd also say that I think, at least in the U.S., the focus on consumers is an appropriate aperture for antitrust. Are there things that should be changed relative to antitrust law? Potentially. Certainly, resources, those kind of things should be looked at. Whether there's lookbacks, the FTC is engaging in that kind of thing right now, looking back at past acquisitions and other things. But representing a company that has been through a lot of investigations, I think we understand that kind of scrutiny, and I think that kind of scrutiny is appropriate. I think it becomes hard once we start going down these specific issues of neutrality and content and diversity of speech. I think antitrust laws are not the right platform by which to look at those things.
I'm going to move to some of our audience questions here in another minute, but I wanted, if I can stick in 2 more of my questions. One of the things I found most interesting yesterday was Amazon's Jeff Bezos acknowledged that the company does sell its Echo speaker below the cost at which it is manufactured. This is known in antitrust as predatory pricing. So Amazon is making a product and then selling it for cheaper than it costs them to make, in part because they really want to be the biggest smart speaker provider out there. Under US antitrust law, that's a really, really, really hard case to make. There's another company that is currently suing Google. So if you don't want to talk about that, Markham, that's okay, called Sonos. They had testified earlier in February about their lawsuit against Google, and also sort of concerns with Amazon. They're not as big a player, they're a small player. And so they can't sell their products below cost, but they can't, move money from another area of their business to help cover that. But they do also have a sort of, innovative speaker technology. I mean, do you think either of you guys that might be an area that's fruitful for Congress to look at changing the law?
I think it's fruitful for the investigative agencies, the enforcement agencies, to take a look at that stuff. it's weird for, so yeah, let me answer your question. Yes, I think Congress should overrule the predatory pricing cases. That if they were going to do an antitrust bill, I mean, I have a bunch of ideas for what they would do, but overruling Brook Group, which sets these absurd, sets these extremely, as you know, extremely impossible to win situations for predatory pricing situations is terrible. And I think that it does, I often am someone who says, no, antitrust is very flexible, can do a lot of stuff. It's just a sentence or two. But I think this is one area where really the law and the agencies and the courts are not getting what is going on. So you have, a battle for the gateway of the future, which is already the present, which is these, the assistant space. And yeah, as you suggested, there, Amazon, Google, Apple, to some extent, they're throwing everything at it. The idea that there's like anything like fair competition in that area is crazy. And but they're battling not so much for the monopoly in the devices, which is how antitrust law thinks about it, but for the occupation of the space. In fact, in ways, the control over the attention economy in that area, where whoever has and for the data in that area. And that's an area where it's a great area where the law, it would be thinking, well, are they trying to, own this market so they can jack the price of the echo? But no one thinks that's what's going on. It's to have more data, have more attentional kind of control, and have a better control of the gateway by people get things. That's what the battle's all about. And it's I think, really hard for antitrust to get a hold on. That's a market that I'm personally very interested in, and think, so yes, I guess that's my bottom line.
Markham, do you have anything you want to add there?
I think the case you're referring to is not an antitrust dispute, but an intellectual property dispute. I'm not totally familiar with that, even though I think they've made it's come up in stories as the other. I think to balance that out, the concern around sort of predatory pricing case law is this trend that's happening, particularly in Europe, though, that's really trending toward preventing any kind of efficiencies in terms of vertical accumulation or vertical inputs into a platform. And it's hard to think about, as I see that trend, where the logical end to that is. So in other words, if you're buying a German car and it comes with a certain kind of tires and a certain kind of stereo system, are we really to say that we should be disaggregating that so that people can choose 6 or 7 different types of stereos with that car when they're buying the car, or 6 or 7 different tires? And it might sound like a bit of an extreme example, but that's sort of the trend that's happening in Europe. And what has happened in Europe is they've taken sort of these facially neutral laws, and I think not being satisfied with the outcome of cases and investigations they've run, rather than say we should look at a horizontal approach to update antitrust laws across industries, including car manufacturers and airplanes and hospitals and everything. They're essentially saying, let's define our antitrust laws and define it in such a way that just so happens to hit 4 or 5 companies from the United States, to say, let's give our domestic companies a chance to compete. And I think, again, we want to be wary of unintended consequences as we look to sort of achieve policy outcomes or competitive outcomes to protect or prop up certain types of players in the ecosystem. And I think that kind of short-term thinking is not good for the consumer, right? And can slow the pace of innovation.
Yeah, so I just want to add, sort of following up on what Markham said, there is the European Commission is considering some regulations right now that it hopes that it may have a draft by the end of the year to deal with what they're calling sort of digital gatekeepers. And those are the major companies, the people who appeared at the hearing yesterday, who they say sort of act as the gate through which people or companies or consumers have to interact through. And one of the proposals under consideration is to have some sort of do's and don'ts. Like once you become a gatekeeper, you can no longer engage in a specific type of activity. One of them is self-preferencing, so that you could no longer give preference to your own products. That's sort of like the case that they brought against Google in the Google shopping case. in which the European Commission alleged that Google favors its shopping product in its searches. And another one might be, what was the one? Oh, like the Amazon example, you can't use data that has been given to you for one purpose for another purpose. So like the sellers give them data for the purpose of listing on the marketplace. Amazon can't then use that data to, for example, try and compete with them in the same product. So we have a couple audience questions I want to get to. The first one, due to insights we heard yesterday about companies using cloud services to compete against their cloud's customers, does anyone see the potential for a law requiring search engines or similar companies to divest of these services?
You want me to take that? It's an interesting
Sure.
idea. Usually that would be the remedy after a full-on antitrust Section 2 case. And whenever people have sometimes spoken about breakups, they're like, well, how would you break up Amazon? What would you do that wouldn't make it inefficient? And some people say, well, what if you broke off Amazon Web Services? Would that make things fair? I guess the question really has got to be to what do you want them to be different? The real question is, to what extent is the favoritism shown? Is it a problem? I think nobody wants to create artificial boundaries, but if it is kind of a natural dividing point. There's something about cloud services that feels more like a common carrier and feels like something that, widely available, it's best in a non-differentiated form, just kind of out there. So I can see the concept, I'll put it that way. Sorry, that was kind of a convoluted answer, but.
It's okay. Markham, did you have any thoughts?
Yeah, I mean, it's interesting, right? In the question that came up, I think it was to Mr. Bezos, he noted that Netflix uses AWS, right? They obviously compete with Amazon in the video space for video distribution. So, I haven't heard of examples where a cloud provider that is selling to a customer is then going to use that data, which I know for Google, that data is considered the customer's data. It's not our data, right? So those are dealt with contractually, and I think it wouldn't take very long if a company were found out to be doing something like surreptitiously spying on data, even if it were not encrypted. Often data like that is encrypted. It would be very hard to look at that kind of data. It's important for other reasons, law enforcement access reasons, and others. That kind of data is considered the client's and not the platform's data, the host platform. But one would look, I think, to, are there examples of harm out there? How pernicious is it? I haven't heard any of that. And then whether one would want to regulate that, well, what is the competition, the competitive landscape looking like, right? How many providers are there? Or is it essentially, if it's only one, you may want to regulate it, or if there's bad behavior, one could look at different laws. So I haven't seen a case to be made necessarily for a breakup on those reasons, for those reasons, or any allegations really from companies that are hosting their content with a cloud provider, but still competing in some other way with a different part of that provider's business to justify that kind of action. So
we have another question. The last big technology antitrust case was the one against Microsoft in the early 2000s. What was learned from that case that is informing the approach to today's questions about digital market power? Markham, do you?
Go ahead.
Yeah.
Well, that case was really interesting. I think, Tim, you were involved in that case. I was involved in that case as a young lawyer. Remarkably, that case, if one remembers, the district court did order the company to be broken up, and then the circuit court overturned that, I think, on this finding that the judge had used the wrong standard, a per se standard rather than a sort of a reasonableness test standard, and then the case settled out. That case, I think, would be used by many to say, well, it shows that the antitrust laws are not irrelevant in a time of fast-moving technology, and that there was a remedy there that could be applied, even a remedy to require a company to be divested at that time. That was a case of, a tying case where it was found that, if I remember correctly, that Microsoft was not only bundling their own product, but then foreclosing against potential rivals in various ways. And so, that is kind of a classic antitrust case, a monopolization case, and I think, at least the way I view it from my perch, shows that antitrust laws are able to go after the kind of conduct that we would think of as being anti-competitive, even in the technology sector.
I think Markham's right. There's a lot. That is the case. Thanks for asking that question. That is sort of the stage setter, I think, for all of this conversation, and certainly, in the discussions I've had, it is the state's relevant law. It actually, just to put it in context, it was the third of a trilogy of big high-tech cases that had huge impacts. AT&T was broken up into 8 pieces. IBM underwent a 13-year ordeal, which ended up with the company weakened, and did a lot of things along the way, like inventing the software industry, for example. And then you have Microsoft. I think Microsoft had a lot to do with the ability of Google, companies like Google and Facebook, and certainly Android, to get its start, in the sense that it gave Microsoft a strong lesson about using its browser, or using its operating systems, a browser being like, using its platforms to destroy its competitors. That it wasn't supposed to. And Microsoft spent a lot of the early 2000s with what we call a policeman at the elbow, kind of watching them, and like IBM or like AT&T, kind of nervous about getting in trouble again. I think that made a huge difference for actually today's internet giants. So it is the case. And maybe I'll say one last thing. In fact, I had a chance to talk to Bill Gates about it. It's I eventually got to the topic. It wasn't the first question I asked him about, because sort of delicate topic. But yeah, he said, that totally sidelined us for, maybe their products weren't that good. He said, we would have had, he thought he would have had the mobile operating systems if he hadn't had that. I think he said that publicly as well. So it's a huge case. And one thing I think that is really important about it, I'm going to lead me back to Facebook, was the idea at the core, they found an internal program designed to eliminate the competitive threat of this new thing called the internet. That was the Internet Tidal Wave memo written by Bill Gates. It's like he saw ahead. He knew that the internet was coming and it was going to destroy their power over, make the operating system less relevant. And so they had to do something about it, which ultimately they wreaked havoc on Netscape. I think, and I hate to go back to this bombshell with Facebook, but I think the documents that were leaked at this hearing yesterday, not leaked, the documents that came out for Facebook look a lot like the same thing. It's like, all right, how do we prevent there from being, a company that displaces us, and what do we do about that? So I think it's all, go back, read Microsoft if you find yourself bored or something, because it's got all the answers.
And we have another question, getting Danielle a little bit back into the conversation. So Section 230 is used by companies like Facebook to permit advertisers on their site to discriminate on the basis of protected categories. To what extent should Section 230 be adjusted in regards to civil rights, not just crimes?
So that was, I have to say, it was such fun. It's such fun being on this panel, because I feel like I know so little about antitrust, but know it from the work of, let's say, Tim and Markham. So that was like just joyously fun. Okay, so back to the question. Spencer Overton testified before, I don't remember which committee, but he specifically argued that Section 230, to the extent that we're going to have a piecemeal approach, as we did with FOST and CESTA, that we should ensure that federal civil rights laws, like federal criminal laws, Markham told us, right? There's some things that fall outside of Section 230's lens that included, along with federal criminal law, IP, and the Electronic Communications Privacy Act. We also should exempt federal and state civil rights law. And to the extent that we're going to be cherry picking, and I don't love piecemeal approaches, but I agree with Spencer, I'd start there. I think a lot of the egregious harms we are seeing is platforms sort of not only making money, obviously, through data, but leveraging their systems in ways that have really, really disturbing distributable impacts, especially on the marginalized. So I'm with Spencer Overton, and he's got some great testimony on point.
Well, thank you so much. And that actually brings us to 2:30 and the end of our panel. So thank you all so much for spending some time chatting about this. This was a great conversation. And thank you all for joining us here online.
Thank you.
Thanks.